Good afternoon, this is Sean Golding with Golding and Golding, here to discuss the basics of the substantial presence test. What is it, who does it apply to, and how do you avoid it? So basics, right? In the U.S. follows a worldwide income and reporting model, which means U.S. persons, not just citizens, are taxed on their worldwide income and have to report their global assets, accounts, and investments to the U.S. government. It doesn't matter if Jim lives in country A, earns all of his income from country B, and has no income in the United States. If he's a U.S. person, he has to report all of that income on his U.S. tax return. There's three main categories of U.S. person individuals. There's U.S. citizens, lawful permanent residents, and then the third category, which is foreign nationals who are not U.S. citizens nor legal permanent residents, but they meet the substantial presence test. Excuse me. So what is the substantial presence test? The substantial presence test is essentially a counting days test in which the government says, hey, you may not be a U.S. citizen, you may not be a legal permanent resident, but you've overstayed your welcome. You were here so long in the current year and 2 prior years combined that we're going to begin treating you as if you were a U.S. citizen or a lawful permanent resident. And the way you do the test is like this. It's 183 days, but it doesn't all have to be in the current year. A person does have to be in the U.S. for at least 31 days in the current year, or else the substantial presence won't apply to the current year. But it's a 1-to-1, 3-to-1, 6-to-1 test. Basically what that says is, in the current year, if you were here for 100 days, then 100 days counts toward the substantial presence test. In the prior year, you were in the United States for 90 days, well then divide 90 by 3, 30 days are going to apply to the test. In the year before that, so 2 years back, you were in the United States for 180 days, divide that by 6, and so for 30 days, that's going to count toward the substantial presence test. Even if you meet the substantial presence test, excuse me, even if you meet the substantial presence test, there are other ways around it. For example, you may qualify for the closer connection exception, which says that you have a closer connection to a foreign country or multiple countries. It doesn't have to be one. There's also certain exclusions depending, like for teachers and things like that. And then depending on the type of visa you have, sometimes you may be able to avoid it. Like if you're here as a student on the F1 visa, for the first 5 years that you're on it, you are not considered a U.S. person. Even if you're living in the U.S. full time, that won't count toward the substantial presence test. So what does that mean if you meet the substantial presence test? Well, unfortunately, if you meet it and there's no exceptions or exclusions, then the U.S. is going to treat you like a U.S. person, which means they're going to tax you on your worldwide income, and they're going to require you to report your global assets, accounts, and investments to the Internal Revenue Service as well as FinCEN. Now, for some people, if you're like a citizen, a permanent resident, you live overseas, you may be able to qualify for things like the foreign earned income exclusion. But if you're in the United States, chances are you meet the substantial presence test as a non-resident, as a non-permanent resident, non-citizen, because you're living here for a significant amount of time, so you may not qualify for things like the foreign earned income exclusion. It's totally unfair. So for taxpayers who can qualify for one of the exceptions or exclusions, it's super important to try to do so. One of the other drawbacks for not knowing that you met substantial presence and therefore not properly reporting your income or your assets or accounts is that now you may be subject to penalties. And forgetting all the ridiculous fear-mongering, scaremongering that you'll undoubtedly find in your Google research quest, the IRS does like to enforce international penalties. They're not necessarily based on any amount of income due. It's just, hey, you got a foreign trust, you didn't report it, boom, 25% value, or 35% value even, depending. You got a gift from a foreign person, didn't report it, 25% penalty if more than 5 months have passed. And you know what? There's no unreported income. For the F-bar, the penalties can be utterly outrageous. So if you're out of compliance and you want to get into compliance, there's various amnesty programs. They're called Offshore Voluntary Disclosure, F-bar amnesty, things like that, that you can use to safely get yourself into compliance. There's VDP, which is the Voluntary Disclosure Program, which is for people who are willful or just can't certify under penalty of perjury that they're non-willful. They're the streamlined filing compliance procedures, domestic and foreign. They both apply to foreign money, or offshore technically. Just domestic is for U.S. residents or non-foreign residents. Foreign is for foreign residents. That's probably the best program out of all of them because there's no penalty. There's also things like the delinquency procedures and reasonable cause, We have lots of free information available on our main websites and all of our sub-websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.